There we go. All right, we'll give everybody a chance to get in here, and we will call to order the subcommittee on Senate File 2215. This is an issue that has gone through the legislature before and before my time in the legislature. What we have before us is a bill that mirrors a Kentucky law that the Supreme Court declined to review and thus left into place. The bill would require that prior to a woman providing informed consent to an abortion, that a doctor or tech must do the following: perform an ultrasound, provide a description of what the ultrasound is depicting, display the ultrasound images so that the woman may see them, locate the heartbeat so that the woman may hear it, provide a medical description of what the ultrasound shows, and get a certification from the woman that all of the following, all the above occurred, or whether or not she refused to do so. And importantly, a woman is not is allowed to not watch an ultrasound or listen to the heartbeat, and neither the woman or the tech are subjected to a penalty if they refuse to do so. So, big picture stuff here. The bill is, it does not prevent an abortion. It merely provides information to a pregnant woman to ensure that she can provide informed consent and understand the options that are available to her. The legislature intended this several years ago as a matter of public policy, and I feel, and we've had these discussions well, frankly, last week on the floor, I feel that the Supreme Court wrongfully invalidated and found a right to an abortion under the state constitution, and so we're working to fix that with SJR 2001. But now what we have before us is a look at a sister state law that the Supreme Court declined to review. Now, you only need 4 votes for the Supreme Court to review a case, and the court declined to do that here. And I've read some, over my years, some interesting dissents from denials of writs of certiorari. I don't know if there were any here, on a number of topics. And so, to me, that could be a signal that if you overlay the undue burden standard that was laid out in Casey and the progeny, that the court may well have found that this would have passed muster. But in Iowa, our jurisprudence is a little different because now we've applied it to our court, a state court, applies strict scrutiny to this. So, what we have here, though, is a limited wait period and some prerequisites to ensure informed consent for a significant medical procedure and a significant life decision. I'm paraphrasing this, but Justice Mansfield in his dissent noted that our law contemplates wait periods in other areas. 3 days for marriage under state law, unless you want to go to Reno. Adoption after birth, 72 hours, divorce 90 days, and there are others. So what we have before us is a bill. It does not prevent any abortion. It just merely applies some of those other waiting periods that we do have in other areas to give individuals additional information to make sure that they are able to make an informed decision on a major medical procedure and a major life decision. That's the overview, and those would stand to be my opening comments. I want to give both senators an opportunity to speak, and then what we'll do is we'll just work our way around the room and give everybody an opportunity to speak on it. Do either of you guys have any opening comments?
Yeah, I have a number of questions. First off, it looks like the bill's sponsor is Senator Brad Zahn. Did he give you any indication of why he was bringing the bill forward today? I
have not talked to Senator Zahn about the bill.
What type of abortion does this legislation cover?
I think what it does is, I think it would probably cover all types of abortion. There are exceptions in there where if it's medically necessary procedure to save the life of the mother, that the requirements of the bill would apply.
So would spontaneous abortions be covered in this legislation?
And by that term, are you essentially like a a miscarriage.
Correct.
I cannot answer that right now, but I can dig into it, work with the drafters and stuff.
I mean,
Yeah.
that's a pretty significant question if you're unable to answer whether miscarriages are covered under this. 1 in 4 women will experience a miscarriage in their life, so we need some clarification on that.
And I guess I would say maybe it does need to be clarified. I mean, I didn't want to give the incorrect answer.
But you don't know the answer.
I don't know the answer. I would say my best informed reading of it would say no, a miscarriage would not be captured under the requirements of the bill.
Okay. Now, if a woman is experiencing a spontaneous abortion, how would an ultrasound be done if the woman needs a medical procedure?
So there's a provision in here. It's kind of the point I alluded to before. If it is medically necessary to perform it, the requirements of the bill don't apply. So you would, if in the judgment of the doctor it was medically necessary to save the woman's life or prevent possible detrimental physical effects to the body, then I would say probably the requirements of the ultrasound would not apply.
Well, it says only to, under the way the bill is written, it says to preserve the life of the pregnant woman whose life is endangered. And oftentimes when a woman is experiencing a miscarriage, her actual life is not in danger. So that would not cover her the way you have medical emergency covered. How many spontaneous abortions occurred last year in Iowa?
I don't know. We can research that and help find an answer for you.
Okay. Well, it's in the thousands, and I'm just curious. It's in the thousands alone just for the Medicaid population. So my question to you is how many additional ultrasounds will we be giving to women in our state under this legislation? Everyone that requires some type of procedure would be required to have an ultrasound, correct?
Again, I'm, without having spoken to the sponsor of the bill to understand his intent of it, my judgment would be for purposes of an elective procedure, that this is what the bill would apply to. So it's however many elective procedures there are, that's probably how many ultrasounds.
So do you believe getting your uterus when you're in the middle of a miscarriage would be considered an elective procedure for Iowa women that maybe want assistance while they're going through a miscarriage? That you consider that elective?
So, okay. If there are complications with the pregnancy, an ultrasound can help determine whether or not the pregnancy could continue. So that may be an appropriate medical tool to use. If it is so to the miscarriage is so to the state of seriousness that it endangers the life of the mother, again, I don't think the requirements of the bill would apply to that. On notice and informed consent and all these other prerequisites.
Well, you have a 72-hour waiting period in the legislation. You can't confirm that this doesn't apply to women who are going through a miscarriage. And for them to have to fill out a permission slip and wait 72 hours before that they can get medical assistance is simply inhumane. You also have on lines 13 and 14 information about fetal demise, and that a tech would be required to tell a parent that there was fetal demise. What is the current procedure for a parent who gets an ultrasound where they detect fetal demise?
What's the current procedure?
Yes.
It is a subcommittee looking for language. So if there's some language you think that could help clarify all this, we'd certainly be open to it.
Well, I'm asking you. You guys are the ones running the bill. I just
Sure.
am curious what you mean by fetal demise. Are we now letting techs do the work of other healthcare providers? I mean, you're telling a tech that they now have to inform a parent of fetal demise. Is that your intent?
I mean, I think techs that go through the education and training are prepared to determine all types of situations.
Really?
They could. Yes. I mean, a tech is if their education, training, and experience allows them to detect someone, I mean, not related to a pregnancy, a broken arm or something like that. If their training goes to them, if they are the one that's performing this and detecting it, I don't know if hospitals have best procedures. If they would say in a case where we're talking life and death, do you bring in a doctor, for example, to review this?
What kind of ultrasounds are you mandating in this legislation?
The bill requires the performance of an obstetric ultrasound, and I believe the bill defines that later on page 4 to mean the use of ultrasonic waves for the diagnostic or therapeutic purposes, specifically to monitor the development of an unborn child. So probably any of those technologies that the medical professional would deem appropriate based on the circumstances.
So what type of ultrasound would you use in the first few weeks of pregnancy under this legislation?
I think that medical professionals could determine the appropriate.
But you're dictating what they have to tell their patient, and that they have to do an ultrasound. What kind of ultrasound do they have to do in order to meet the requirements under this bill?
Any type of ultrasound that meets the definition of ultrasound in the bill. So any use of ultrasound.
So Senator
waves.
Zahn, Mr. I don't believe in traffic cameras is now going to dictate that government require vaginal ultrasounds.
There are transvaginal ultrasounds. There's also ultrasounds, outside the body.
And do those work early in pregnancy?
We had ultrasounds at early stages of life on my wife's stomach.
So what week?
Somewhere between 6, 8, 10, maybe.
And were they able to do all of the requirements in this legislation?
I don't know if they were. Our kids were born in different states, and we weren't pursuing an abortion.
I guess then my question is, are you saying that you are not going to require transvaginal ultrasounds for Iowa women under this bill? Because if that is the case, you probably should put that in an amendment. Are you wanting to dictate transvaginal ultrasounds?
What I want to do is allow doctors, as they help people determine how to give informed consent for a medical procedure, use their judgment to determine what type of...
Well, you don't want to use their judgment because you just outlined exactly what they should say and do. So basically, if you want them to follow your requirements, you are going to mandate them using transvaginal ultrasounds. You're going to mandate a transvaginal ultrasound for Iowa women and girls. Am I correct?
No, not mandating a transvaginal ultrasound. if another type of ultrasound technology is available and the doctor determines that's appropriate.
Well, that wouldn't work early in pregnancy. Not for what you're calling for. Do you want to put an amendment in that says they absolutely are not required to use that form of ultrasound?
I would be, Senator Petersen, any amendment language that you have and that you would bring forward.
This is not my legislation. I would throw this in a garbage can. That's what I would do with it.
I'm not going to throw it in a garbage can. We've had a lot of issues. I mean, Senator Schultz and I were on a subcommittee earlier today where there's a lot of people in the room that didn't like it. If there are ways to make it better or less worse, whatever your perspective is.
Yeah, that's the garbage can technique. That's what I'm recommending. But if you are moving forward, I want all Iowans to know that the way this is written, you are dictating an ultrasound on women and girls, the most intrusive form of ultrasound. That is how this is written. This is written that you would require that of a woman who's going through a miscarriage. That's how this is written.
I don't read it that
It's
way,
not-
but if you
Well-
do, that's something that we can work with the draft.
I
with
will
the
be
drafters.
very interested to see how you can fix this. I also want to know exactly who will be required to be a part of the 72-hour waiting period.
Who would be required to be a part of the 72-hour
Yes.
work period?
Yes. I want to know if you're going to demand Iowa women going through miscarriage to wait 72 hours before getting medical assistance.
Again, I don't view that as the intent or the purpose of the bill. That's not my intent. Again, without having
It's not my reading either.
spoken to the sponsor of it.
Well, I'm sad that he's not here to explain his legislation that he's forcing on women and girls in our state.
So I guess one thing I would say, Senator Petersen, is we've got overarching competing ideological differences on life versus choice, right? That's within the framework of all this. So I would, welcome any ideas that you have to improve the bill. Ideologically, I would probably find it'd be difficult for you to support it. But if through this discussion, and certainly from hearing in everybody around the room, if there are ways that we can capture and improve to not capture those things that may not have been intended. I'm not trying to use a flippant example here, right? Do not think that I'm equating this. I had a deputy sheriff from my district who wrote an email to me about Thursday night right before the bill draft deadline, and wanted to write a bill to have people provide notice to law enforcement when they jump their car. I sent that to LSA. They did a great job drafting it. Unfortunately, it didn't capture at all what it was that I intended. And again, I'm not trying to, this is not apples to apples comparison. So what we did then is we just did a strike after amendment and completely, rewrote the bill to try to capture the intent. So again, I can't speak to the intent of Senator Zahn in requesting this bill, nor to the specific draft or how it was drafted. It would not be my intent where there are at question potentially the life of the mother being affected. It would not be my personal intention to have them captured under this bill.
Well, we're in funnel week. Subcommittees are the only time for the public to get an opportunity to speak on legislation. So would your intent be to maybe go back to the drawing board and come back with a piece of legislation that Iowa women and girls have an opportunity to speak on once you've maybe gone back and looked at how some of this might impact women that are enduring heart-aching pregnancy loss, and give the public a chance to actually look at a piece of legislation that might be better thought through?
So any decision on any bill to be brought up, I would defer to the chair on that. I would say a couple things to that. One, as a broad policy, this is something that has been considered by the legislature because they passed a law a couple of years ago. And so
It was ruled unconstitutional.
Sure.
Correct.
And so, but there was a deliberative process over the course of a couple of years. I still think this affords us, and I'm looking forward to getting the public input, on this. That's what this subcommittee process is and is for. And we do have very good staff and very good drafters at LSA that I think can listen and can incorporate those things in a timely manner if the chair decides to move forward with it before the funnel. And then, of course, we have the other chamber, opportunity for debate, discussion, and improvement there through their subcommittee process. And that's before it even gets to the floor. So,
But don't you think a bill that affects a woman's body, where you may be forcing a camera inside of a woman's body, that those women and girls, if you're going to rewrite a bill, those women and girls should be able to come forward and ask question in a public setting?
You're kind of blocking them from doing that right now.
Okay, well, let's turn it over then and let people ask questions. Thank you, Senator.
Senator Schultz, do you have any?
This is the process in the subcommittee to find out what language fits into Iowa code and what definitions we need that aren't found elsewhere in Iowa code. I appreciate having the subcommittee. I'm glad we have people all the way around the room because it's an important issue. It matters. It matters to people on both sides. So I appreciate the questions so that we can address some of these issues. I mean, that's fine. This is an opportunity for the public to speak on it. I appreciate that after what I think is at least evenly and mostly considered an act of judicial activism, which set aside the last one we had, which had been vetted for years. That's why that one was fully prepared. That one was good and went to the Supreme Court. This one, we're looking for language that uses techniques and language that have been vetted by a court and decided not to overturn. We have to make it apply to Iowa code. We need to find which definitions are not elsewhere in Iowa code that can be referenced. So I'm interested in hearing from the public to find out what we can do. The subcommittee you referred to earlier was almost identical to this. We laid out a good piece of legislation, model legislation, that would deal with welfare reform, and we asked the public what parts of this don't apply to our experience here in Iowa. We got a lot of good information, and I'm looking forward to good information here. So with that, I'd like to get to the public because this is the portion in which the public gets to speak.
We have an even divide here. I work better as I process this way, like reading a book. So we'll start right here.
Chuck Hurley, the family leader, thanks for bringing the bill. Some of us have been around since before Roe versus Wade. We've heard a lot of arguments on this issue. The one thing that I don't think anybody in this room can argue away is that little child in her mother's womb is a baby. And so for you to try to assist in making a decision, a life and death decision about that baby is to be commended. And I thank you from the bottom of my heart.
And we'll just work our way across. If anybody wants to introduce themselves, or I guess we'll, yes.
Sorry. Feel tight over.
And we tried diligently to try to find a bigger room, and we found that it just was not possible, so we picked the hottest room in the whole house.
I'm Connie Ryan. I'm the Executive Director and Lobbyist for Interfaith Alliance of Iowa Action Fund, and we are registered strongly opposed to the legislation. I appreciate Senator Petersen's questions and comments on this. We believe strongly that women have the right to make their own healthcare decisions. and for the government and religion to not interfere in that process. I'm deeply disturbed by the lack of knowledge and information in the questions and the answers that were given to those questions. I believe that, and Interfaith Alliance of Iowa believes, that women and their doctors and their families and whomever they trust in their lives are the people to make those decisions. This bill is a clear attempt to interrupt that process and interrupt the lives of women and families in the state. It is really an abomination to the rights of women. I also would take note of the phrase activist judges. That is simply offensive to the courts, and I'm really tired of hearing that. They are not activist judges and justices. They are doing their job that our Constitution calls them to do. Thank you.
My name is Maggie DeWitty, and I'm the Executive Director of Iowans for Life, and I am in strong support of this bill and very much appreciate it being brought forward. This bill is about providing women with information. Information is power, especially for a woman experiencing an unplanned pregnancy. She deserves all the facts and all the information. This bill does not, however, force women to receive this information if she so chooses. It allows women to make decisions regarding her pregnancy, but also ensures she gets all the medical information that she needs. Prior to my work at Iowans for Life, I was an adoption coordinator for 10 years. I counseled many women in unplanned pregnancies, and I knew that the best way I could help her was to provide all the facts on her options and what those options entailed. And now my work here has given me an opportunity to talk to many women who have had abortions and were lied to by abortion providers and told their baby they were carrying was just a clump of cells and could not feel pain. Once they were made aware of the facts, they were devastated by their decision to end the life of their unborn child. If we truly care about women, we cannot deny them basic information in order to make a life decision that they have to live with for the rest of their life. I strongly urge this bill moving forward to committee. Thank you.
Good morning, I'm Jim Lamb. I'm a life advocate with Lutheran Family Service, and we are very much in favor of this bill for similar reasons that it provides women and their right to choose with information that they need to do that, more information. For, wow, almost 40 years, I've been an advocate for unborn little boys and girls, but during that time I've also been an advocate for the moms who are carrying those little boys and little girls. And I led an organization for almost 20 years, and we also had a hotline for post-abortive men and women to call. And we received just over 300 calls every month on that hotline. And some of the things that we heard were this. These are their words, not mine. I wish I hadn't. My doctor made it sound so easy. They told me it was only blood. The nurse said it would just be tissue. And then this haunting question almost always came after that. Why didn't someone tell me? And I guess that's the question I would pose for those who would oppose this bill. Why don't you want to tell them? Why don't you want to have them understand the true reality of who they are carrying? Why don't you want them to hear that heartbeat? Why don't you want them to have time to get all the facts and consider this life and death decision that they're making for their own child? Now, I think all of us know, if we've done the research, that abortion-minded women, when they see their little boy or girl in an ultrasound, the vast majority of them change their mind. So is that what you're afraid of? That a woman would exercise her right to choose by choosing life instead of death? I would pray not, because that's a very anti-choice kind of position to take. Why didn't someone tell me we're in favor of this legislation so that fewer and fewer women will have to be haunted by that question? And if I might just speak, Senator Petersen, to me and to those who are bringing the bill forward, to me it would seem that a lot of your questions would not exist if the language of the bill would say induced abortion rather than just abortion, separating it from a spontaneous abortion. All those questions would go away. Just my suggestion.
Jane Robinette, I live in Urbandale. I think it's offensive to doctors and women that you feel you need to specify what informed consent entails for this specific procedure, specifying mandatory invasive procedures, mandatory language, and more. It doesn't respect women. It doesn't respect the relationship between women and their doctors, and it's just offensive all the way around.
Hi, I'm a student from Coralville, which means I carry no weight in society whatsoever. Thank you for the laughter. I'm just here actually to pose a question to Senators Whitting and Schultz. Hope I'm addressing you correctly. Do you guys have a right to refuse treatment? Yes. What about the people affected by the bill proposed? Do they have a right to refuse treatment? They do? Okay.
Without criminal penalties in the end.
So my concern is, so for an ultrasound procedure, which evidence clearly shows that is not medically relevant for or medically necessary for a woman seeking abortion, that aside, requiring people to get a procedure, they simply have a right to refuse it. That's my first concern. I think my second concern is clarification needed. Would women who have been victims of sexual assault be required to get an ultrasound procedure as well if they were seeking abortion? Isn't it possible that that act might be re-traumatizing in some ways for a healthcare provider to do something that they may have no interest in receiving? Third point, I think as was alluded to, I think earlier, I think I worry about violations for physicians, for healthcare providers who do not abide by this rule. I think last but not least, as was raised earlier, the idea of a technician having to not only provide that determination, but that communication of fetal demise is very scary, to say the least. And that's all I have.
Rita Carter with the Iowa United Methodist Church. We are currently registered undecided on this because we do have some problems with it, some questions. I thought, Senator Whiting, I thought I heard you say there were no penalties for refusal. And I see penalties in here for the technician and the doctor. Page 3, lines 19 to 23 says they're subject to penalties. The United Methodist Church position on abortions is that we mourn them, we value life, but in the final analysis, we stand that it's the woman and the doctor's position and choice. And so we're kind of leaning against, but we do have problems with this. And we're talking about 72 hours, that's 3 days. We're talking about days. And so I think the crisis kind of situations wouldn't apply here, and that needs to be clarified. So all I have to say.
Hi everyone, I'm Jamie Birch Elliott, lobbyist for Planned Parenthood Advocates of Iowa, Planned Parenthood North Central States. We are opposed to this bill, and I want to be clear that we're not opposed to ultrasounds, but we oppose this legislation because it dictates the conversation between a patient and a doctor, and folks have mentioned that previously, and that's an inappropriate and dangerous precedent to set. Doctors and their patients, and certainly not politicians, should determine the healthcare needs of patients. I think we learned today, if nothing else, legislators are not physicians and do not belong in exam rooms with patients. And so with this bill, legislators, politicians are setting the standard of care. And really that is not a decision, that's a decision that should be between the doctor and the patient. Leading healthcare organizations like the American Medical Association, the American Women's Medical Association, and the American Public Health Association oppose legislation that oppose specific requirements for medical procedures because they interfere with the doctor-patient relationship. And so, the New England Journal of Medicine, one of the nation's major leading medical organizations, denounced such laws as this as inappropriate legislative interference, and noted that lawmakers increasingly intrude into the realm of medical practice, often to satisfy political agendas without regard to established evidence-based guidelines for care. So that's from the New England Journal of Medicine, right? And so this bill is demeaning and disrespectful to Iowans because it assumes that they've not thought about their decision carefully and thoroughly, and it's insulting to doctors and nurses that care for them because patients deserve their physician's best medical judgment and counsel, not unnecessary requirements mandated by politicians. And ultimately, this undermines long-standing practice of informed consent. This bill is not informed consent, and in fact is interfering with the informed consent process. When a patient and their doctor openly discuss the diagnosis, prognosis, and possible options, that is informed consent, right? And this bill is clearly not about healthcare. That was abundantly clear today. This bill is clearly about shaming a person for their decision to end a pregnancy because it assumes they have not thought about their decision or that providers are not giving them information, right? So this bill is not about a person's right to know all the medical information before they make a decision. Women already have that right, you see, and as health professionals at Planned Parenthood, we have a legal, professional, and ethical obligation to share with the patient all the relevant information about the range of healthcare choices that are available, including the benefits and risks of treatment, and to respect the patient's decision. And so know that this bill does not enhance health or safety of patients, and this bill substitutes a government mandate for a doctor's judgment about how to counsel and interact with a patient. Physicians are already fulfilling their legal, ethical, and professional duty to ensure that patients understand the breadth of treatment options, benefits, and risks. And instead of shaming patients about their decisions to end a pregnancy, we should make it easier for them to plan a pregnancy by ensuring access to contraception. This bill is just another unnecessary restriction on abortion providers, and it's designed to shame people and has no basis in sound or recommended medical practice. Thanks.
Hi, I'm Alyssa Miller-Hurley. I'm with NARAL Pro-Choice Iowa, and we are here because we are against this bill. We believe that women are already making informed decisions about their health care, and that this is yet another vehicle and political tool being enacted and pushed by extremists who really have no place in the exam room. Our belief is that we should really be trusting women and patients to make informed decisions about their reproductive health care. It was brought up earlier that women tend to regret having an abortion, that they go into the decision uncertain. That is factually untrue. In study after study, it has been shown that women are more sure about having an abortion and about making the decision that is best for them and their family than they are about almost any other medical procedure. On average, a woman waits between 10 days from when she is pregnant to when she finds out she's pregnant to when she makes an appointment to schedule an abortion. in a recent study, it was looked at over 500 women on whether or not they had any qualms about making an appointment, setting an appointment, and following through with that appointment. Over 95% of those women came out of that study saying that they were more sure about having an appointment than people who had been entered into a study on having a knee replacement. Forcing women and subjecting them to an unnecessary, invasive procedure with the purpose of trying to shame them out of a decision that they have already thought through is not only wrong, it is unconstitutional, and it is setting up another barrier to access. We are creating a barrier to access for people who are already facing systemic barriers that have been put in place by the same people in this room. Rather than making it harder to receive reproductive health care, we should be making it easier. We should be making it easier to obtain contraception. We should be making it easier for our children to receive comprehensive sex ed. And we should be making it easier to give safe birth here in Iowa. This bill does none of that. And rather than focusing on restrictions and furthering extremist tendencies, we should be working together to find a way to make sure that the state of our care here in this state is actually good and up to its highest standards.
Hi there, I'm Laura Hester with the Iowa Coalition Against Domestic Violence. We urge you to oppose this bill. We are strongly opposed. Again, just to remind, reproductive health services are a central component of care for all women and for victims of domestic and sexual violence. From experience, our providers will tell you they have acute need for timely access to care. As you've heard today, what's misguided and disingenuous to say that just for people who oppose this bill that we don't want women to have information. Of course we want women to have information. What we're saying is women don't show up without being informed any more than any of you show up for a medical procedure without being informed. Doctors also go through medical training. They don't need legislators to script what they should say. So it's disingenuous to say that, oh, just because we oppose this bill, we don't want women to have information. We want women to have information. We want women to have accurate information. And it's also disingenuous to say, just because this bill doesn't ban abortion, that it doesn't interfere with access to abortion. But for the folks we serve, it does interfere. 72 hours is a long time. And sometimes the nature of reproductive health coercion and dynamics of domestic violence mean that women have thought carefully about their decision. They don't have 3 days. They can't sometimes get out of the house 2 different times to go to it, and then, when it's unnecessary, medically unnecessary. So timely access to care is important. Just because a bill doesn't ban abortion doesn't mean it doesn't interfere with access. If 72 hours means that a victim of sexual assault and domestic violence cannot access abortion, that functions as a ban. And we just urge you to oppose this bill. It's, I think we have enough restrictions as it is. As you said, barriers to access are incredible. Thank you.
If I could, real quick. I just want to say I'm Matt Chapman, and I'm just here to support a woman's right to make their own health care choice. That's all I got.
My name is Tom Chapman. I'm the director of the Iowa Catholic Conference, and we support the bill. One thing that I've seen some recent surveys of women who have had abortions, and after the fact, many women report that their decision was not free of outside pressure to abort. And I think for that reason, it's a good idea for the state of making sure that they have the information they need to make that decision ahead of time.
Daniel Zeno, ACLU of Iowa. We are registered opposed to the bill. I want to talk about 2 different parts of the bill. So the first is the forced view, forced listen ultrasound. And then the second part is the 72-hour waiting period that the Iowa Supreme Court already struck down. So the forced view, forced listen ultrasound. Right now, every woman already has a right to view an ultrasound and ask a doctor to explain it and to talk through it. What this bill does is takes a right and turns it into a requirement that this information be forced on every woman. And in fact, what it does, even though it allows a woman to avert her eyes or have the volume turned low, it requires a doctor or a medical provider to say words, right? And so while the woman may avert her eyes, what it does require is that a doctor be forced to say to a woman, you have to look at this image. Like Jamie said, we believe that this is not about informed consent. This is about forcing women to listen to words that the state has decided they should listen to, and not what their doctor thinks they should listen to. We also think this potentially could violate the Constitution, the right to privacy, the right to the First Amendment freedoms. Right, the government is requiring medical providers to speak, to say words. And I'll just quickly, I know we know about state law, but in Oklahoma, Texas, and North Carolina passed similar ultrasound laws. North Carolina and Oklahoma's laws were struck down. And just a quote from the North Carolina decision. Quote, "This provision finds the patient half naked or disrobed on her back on an examination table with an ultrasound probe either on her belly or inserted into her vagina. This information is provided irrespective of the needs or wants of the patient in direct contravention of medical ethics and the principle of patient autonomy." And so we oppose the ultrasound provision, specifically the 42-hour wait or the 72-hour waiting period. I'm sure all of the legislators here are very thoroughly aware of the Planned Parenthood case, in which the court, in addition to finding that there was a fundamental right, specifically struck down the 72-hour waiting period. Specifically said, Iowa Code Section 146A.1, the section that the legislature is trying to pass here, is unconstitutional on due process grounds and on equal protection grounds. And what the legislature is doing is there's some deleted parts of this, but literally passing a law that the court has already found to be unconstitutional. It is astounding to me that the legislature would pass a law that there's no question about whether or not it's unconstitutional because the court has already said it is. And yet the legislature would pass literally the same words. If we look at page 2, beginning at line 18, all the way through page 3, other than the additions, all of that language was specifically considered by the court and specifically struck down on due process and equal protection grounds. And so we urge the legislature, for that basic reason, to not pass an unconstitutional law. And in any case, as many of the other speakers have said, trust women and not assume that women actually don't know what they're doing. Thank you.
Daniel, real quick, how far into page, you said page 2, line 18 to page 3, how far into page? I just want to make sure I got that right.
So I believe it's all the way, essentially through the end of the bill, so that would be page 4, line 25.
Okay.
There are some additions in there, but all of that is 146A.1.
Thank you.
So the court has not ruled on any of the additions, but all of the language that is in code right now, the court has already considered that language.
Great. Thank you.
Daniel Sun with the Family Leader. We're registered in favor of the bill. I note the court didn't strike down that language. They only struck down the waiting period language, and that, as I understand the case, bumped out of order the informed consent provisions. That's my understanding of the case. But Iowa's in a minority of states not already providing this protection. 27 states have waiting periods for abortion. Our neighbors, Minnesota, Wisconsin, Missouri, South Dakota, and Nebraska all require waiting periods for an abortion. And 6 states have 72-hour waiting periods. So this is not unreasonable protection. Right now, Iowa has no waiting period before an abortion, and that is unusual. This bill is also, as Senator Whiting noted, consistent with Iowa standards in other areas. So we have a 3-day waiting period before marriage and a 3-day waiting period before adoption and a 90-day waiting period before divorce. So abortion is more permanent than any of those conditions. You can't get a kid back. So we think that this bill creates reasonable informed consent protections for mothers and their unborn children. And I would say this bill does not require a vaginal ultrasound. It requires an obstetric ultrasound, and my understanding is the most common form of ultrasound is an abdominal ultrasound. This bill doesn't make any specific requirements on the form that ultrasound takes. Thank you.
Cheryl Lehman, and I'm from Solon, Iowa, and I just wanted to say that from what I hear, I am for the intent of the bill, but it sounds like it needs a little, some amendments, because I've had a vaginal ultrasound. I didn't think it was any more invasive than my regular yearly exams, and I think if you think that's invasive, then I would think an abortion would be even more invasive, and I'm all for educating people on their choices, and that to me it sounds like it's a pretty good way to have that informed consent.
And did you walk in, or did we get you when we went around the
No,
room?
I just walked in, but I'm just observing.
Very good. Okay, did we get...
I got skipped when we went around the first time.
I'm sorry.
Oh, that's okay. I'm Keaton Betterton. I'm from the University of Iowa. I'm a Master's of Health Administration, so I work with doctors all the time, and it's one of the most difficult things we have to do when we're developing service lines is make sure that we are not infringing on their scope of practice. As a health administrator without a degree in medical knowledge, I am not allowed to recommend a specific treatment that a doctor then provides to the patient. I developed a service line, and the doctor gives the treatment that they deem most appropriate because they are the medical professional. We also spent lots of hours in our legal classes with legal consult of the hospital talking about informed consent. And informed consent is determined by the provider and not by legislator. And I think that by requiring a specific procedure is not within the definition of informed consent. It is adding something onto the burden that the patient has to go through. And I think you'd have a lot of trouble with fitting that in the hospital setting rather than a legal setting. So it's a very interesting argument that you're making here.
And you said your first name was Keaton?
Yes.
Very good. I just want to get that down. As we went around the room, did we miss anybody else? I didn't mean to miss anybody else. We also have another colleague here who, being a public forum also, Senator Chapman, if you wanted to make any comments, you're welcome to, but you don't have to.
I think I'll reserve most of my comments for debate. This is a very intriguing conversation and a lot of interesting perspectives. You know, the legislature, did he just leave? He just left. We require a lot of different things when it comes to healthcare. We just, you know, Senator Petersen and I worked on cytomegalovirus. Do you remember that? Where, you know, there was notice requirements and procedure requirements. We do that all the time. And I find it interesting that we have 72-hour wait period if you're going to have a child and then adopt that child out. We've got a 90-day wait period if you're going to get a divorce. We've got 72 hours for if you want to get married. Do we not think that those folks have contemplated that beforehand? Of course, but these are life-altering decisions that shouldn't be made in just the whim of a decision. And so I think it's absolutely appropriate to have a wait period. And as pointed out, we're one of a few states that don't have a wait period. 8 states have a wait period longer than 24 hours. And the court did get it wrong. They absolutely got it wrong. And frankly, I don't know of a nicer word than to call it judicial activism. I've kind of scaled it back from judicial tyranny. I thought I've tried making progress by calling it judicial activism. But to rewrite the state constitution, we've made it very clear. And I know that's not what this is about, but if you truly believe that, then put forth a constitutional amendment. You know, that's the process. But we're dealing with that on that side. This is important because it allows a woman the opportunity to really contemplate, to be totally informed. And I don't know how you can see an ultrasound, how you can hear that heart beating, and still believe that's just tissue. As a healthcare professional myself, I'm not a physician, but I am an EMT. And what we do when we go out is we listen for a heartbeat. That heartbeat cannot be detected. We can call in and we can pronounce that person dead. It only makes sense that we have protections in place. And the one piece that continually is ignored in this entire conversation I do believe in autonomy, a woman's right to autonomy. But we must recognize that there are two lives involved in this conversation. The life of the mother and the life of that child. Separate circulatory systems, separate DNA, separate brains, separate heartbeats. And that is the piece that often gets overlooked in this conversation. So I look forward to having the debate on the floor and in committee. Thank you.
I'm sorry, I said I was an observer and I did come in late, but I do want to make a comment. This is not.
Could you just introduce yourself?
My name is Ann Hoffmaster. I'm not a lobbyist.
Nope, that's fine.
This is not about allowing a woman to look at an ultrasound. This is requiring a woman to have the ultrasound. And I think this is a legislative interference in patient-doctor relationship that the legislature should not be involved in. And if you want to talk about judicial activism, maybe this should be called legislative activism. Thank you.
Okay, and thank you. And we'll leave the final comments to in our remaining 3 minutes, the members of the subcommittee, Senator Petersen, Senator Schultz. Do you have any?
I don't. I couldn't say any better than when you said it, and this is for public input, so we have committee more for our comments. I'm okay with citing that.
Senator Petersen, do you have any?
I would like to thank the people that came today to speak up on behalf of women and girls. This bill is clearly not well thought through. There's a number of issues that need to be addressed. Yes, we have different philosophies. I made a pledge the year that I lost my daughter Grace when I was 9 months pregnant that I would do everything in my power to make Iowa a safe place for women and girls to have babies. Our state is taking leaps and bounds backwards. We've become a much more dangerous place for reproductive health care over the course of the past 3 years. And I'm very concerned about it. I'm concerned that we have a Healthy Moms and Healthy Babies Act bill that every Senate Democrat sponsored that has yet to have a subcommittee. I'm concerned that maternal mortality in our state has more than doubled in the past 3 years. I'm concerned that we've lost 37 labor and delivery departments and we believe we're going to lose another 10. I'm concerned that we still have sexual violence in our state and we have religious groups that refuse to sign on and support a legislation to try to make our state less violent for women and girls to live in. This bill is not one that I can sign. Similar to Planned Parenthood, I believe in ultrasounds and I believe that ultrasound conversations should be those between providers and patients and that politicians shouldn't be in the exam room with us. So I will not be signing the bill. I will be looking forward to seeing your amendment. I'm hoping that you'll have language drafted in time for us to share with Iowa women and girls so that they can see how this would affect them and their health, not just life and death health, but let's remember these situations aren't always life and death. There are other impactful things that can happen to a woman's body, and those should be addressed in your amendment.
Thank you. And 2 things. One, I would say also, we at Senator Petersen, you and I haven't had a chance to work together a lot. I don't even know if this might be our first subcommittee together. I try to do good work in good faith with my Democrat colleagues, and I bet if you went around and asked a lot of people in your caucus, they would say that I'm willing to do that. I would offer it to be a 2-way street too. If you have specific language that you would want to bring in good faith, please do, and we will do our due diligence to look at that, some of those concerns. It's not a guarantee of anything other than to say we will give you a good faith promise to put it through the due diligence. And as we've done with our previous committees, any ways that we can try to address those questions that may not have been intended. Again, I'm not the drafter of the bill, I'm not the sponsor of the bill, If anyone is disturbed by, my ability to speak on every, provision of the intent of 2 people, that's fine. That's exactly what this process is for, is to try to improve that. So if you do have any language or ideas as well to bring forth, please do. And we'll look at it and see from our end if there's anything that we can do to amend it.
Well, as I mentioned, I believe this bill is a bad bill and it should not move forward. But I do believe if you are going to force procedures on Iowa women, they deserve a bill that's perfected.
Thank you. With that, we will adjourn.